Good morning, everybody, and welcome to our presentation on what's on the workplace law horizon in 2025. I'm Kate Ashcroft. I'm a partner in Copeland Ashcroft. I'm based between Auckland and Tauranga, and I'm going to be talking to you about the employment law space, the health and safety space, what we're expecting to see this year, before I hand over to my colleague.
Yeah, hi everyone. I'm Shush. I'm a senior associate at Copeland Ashcroft. I help lead the immigration service line at Copeland Ashcroft. Today I'll be talking about, in essence, what's on the horizon in the immigration space in New Zealand and what we'll likely see this year, what we're seeing already, and I'll provide some sort of case updates or case studies of, where we see things are going wrong and what the correct position is in those scenarios.
Thanks, Shush. So for those of us that we haven't, who aren't existing clients of ours, and I know we've got a range of people that are joining us for the webinar today, this graphic just gives you a bit of an idea about where we're based around the country and a little bit of an overview about what our specialisation in workplace law, which is in immigration law, health and safety and employment law, covers. So today we've given you the high level of what we're going to talk about. Without further ado, let me get into talking about the employment landscape. And I want to thank Ashvini Chalia, a solicitor in our team, who's done most of the grunt work in terms of putting together this presentation, which has involved a wee bit of reading of the tea leaves. I like to think that this graphic here is kind of like a crystal ball that we're gazing into a wee bit to see what we're looking at for this year, particularly around government policy, promised legislative change that we don't have actual bills for yet, and the timelines of when we think this is all going to play out. There is definitely some pretty major noise that there's going to be some big winds of change blowing through the employment law landscape for the rest of the government's term, and it is taking a bit of divining to get to the bottom of, well, what is that actually going to mean for employers and how do we see that playing out? So the crystal ball we're keeping in mind. The other kind of graphic I thought we could use here was like an hourglass, because sans running through time, this is coming. We don't have exact dates for much of it yet. So it's really a wait and see, but we'll get you prepared for what we might expect around legislative change, what we have already seen around case laws to the current date. So real easy start place is the minimum wage. That is moving up to $23.50 effective 1 April. Many of you will be across that. And then there are numerous legislative changes promised or working their way through. In terms of questions for this session, I should say, feel free to drop your questions in the chat. We will get to questions at the end, and you'll also have the chance to just unmute yourselves and ask questions when we're through the content of the presentation. So feel free to do that as we go along, and I'll come back to our moderator at the end of the session to lead us through answering those. So start point, there is a promise by the government that it will be introducing a bill to exclude personal grievances for high earners. What does this mean? Basically, the government says, well, perhaps we ought to put in an income threshold for people to be able to take personal grievance claims and exclude people who are on over $180,000 salary. There was some discussion about whether that should be a higher amount, but the government's indicating that this is going to be the cutoff. We don't yet have a bill around this, but we do have a lot of support from the coalition government for it. So we are expecting a bill around this to happen in the middle of the year. What's that going to mean for employers if it comes in? Look, there's going to be a lot of devil in the detail around this, including in particular whether people who aren't able to take PGs will then be able to bring other types of claims. So this was previously the position in New Zealand before the Employment Contracts Act. It is the position in Australia that high earners don't have access to the same protection that other employees do around challenging employer action to dismiss. So will we then have a carve out from people only being able to bring claims in the employment jurisdiction? Will it be more like a commercial dispute that can be progressed? We don't know yet. I would guess that what we'll see if employees in this category really are cut off from personal grievance claims. People who are often in the senior leadership roles in businesses will be looking to negotiate a package to protect them in the event that the employment relationship is brought to an end. So, for example, there might be discussion like there used to be around no-fault termination clauses and the package that's available to the person if that clause is triggered by the employer. It could also be that there's the negotiation to opt into the personal grievance regime. We can expect a lot more negotiation around setting up employment terms for people in this category. Also, employers, will they be thinking, should we move some more of this person's at risk into a base salary so that they can hit the threshold? These are the types of things I expect to see playing out once we get this bill in play. But a lot of the detail to come once we have the draft legislation. This next bill is about excluding restraints of trade. I won't much about the detail of this. Basically, this bill was a private member's bill introduced by somebody in the Labor government, and it's at second reading stage. It's not a priority for government to be progressing this, and it's not employer focused, it's employee focused. So we can probably anticipate that it's not going to get a lot of support with the current coalition government. Partial strike pay deductions. This piece of law is a bill at the moment, so it's working its way through Parliament. It is basically to allow employers to be able to make deductions from people's pay where they're doing partial strike action, and we've seen partial strike action become much more popular with unionised workforces since the ability to reduce pay was removed. We did previously have this right before 2018, so it's really restoring a previous measure that was in place, and it would be to allow employers to reduce pay by a proportionate amount of the reduction in their work effort in terms of the partial strike, or by 10%. So there's a fairly complex way of calculating how you decide what proportion of pay should be deducted. And I would suspect some employers might think that's too hard to get right and it's open to challenge. So perhaps we should just go with the 10% deduction, which is the fallback position if you don't calculate the proportionate pay. We expect that this will pass. The Select Committee report on it is due on the 22nd of April, and it's progressing under urgency.
What's the mechanism today?
This bill, it has been introduced into Parliament. It's about allowing employees the right to be able to talk about their remuneration freely. If we think about our employment agreements in place, they provide that people aren't allowed to talk about their pay or their employment agreements, that there's a confidentiality provision about the way that the person's engaged. And this bill is saying, well, we ought to be able to share that so that we have greater pay transparency. It's important for quality around pay, and those clauses shouldn't be enforceable. So this has been open for public submissions. They've now closed just a few weeks ago, and we can expect a second reading next year. There is some support from the coalition government for this, but hard to read actually whether this one will progress. So watch this space. There's a new proposed contractor gateway test, which the gist of it basically is that if you meet particular gateways, and I'll show you what that looks like, then somebody couldn't challenge the contractor status of the relationship and argue that they're actually an employee. Now, public submissions on the policy consultation closed just a few weeks ago as well. We don't actually have the bill is going to be proceeding here. And in terms of the gateway and what that looks like, here it is. So you can see the test then is, do you have a written agreement that says that the person's a contractor? And in that case, is the person not restricted from working for other people? So we're not trying to have them just working exclusively for us. Is the person not required to be available for a set number of days, times, or minimum period? Or can the person subcontract the work if there are minimum service requirements there? And do we have the ability that the business doesn't retain the right to end the agreement if the person goes and accepts additional work. In that case, yes, the worker is a contractor. I mean, honestly, this isn't too far off what the existing test is. It's just that most contractor agreements wouldn't meet it. So the gateway test, will it be helpful to employers in terms of their engagement of contractors? Yes, possibly we'll have some more clarity around it. But again, like with the high income earners and not having access to PGs, if there are disputes, they will still go somewhere else if they're not going to be decided within the employment relations framework. So potentially this means more complexity in terms of where those disputes might be resolved. And an employer who's engaging a contractor who challenges this and the person is held to be a contractor, you could still end up in a dispute in the commercial or the civil jurisdiction, which perhaps muddies the waters. And so my kind of guidance for you about how to handle contractors at the moment, and there's a case update that we'll come to on this too, is to review your contractor agreements and arrangements and adjust those so that they really are either much more sitting within the commercial sphere as a true contractor arrangement, or moving them onto an employment relationship, basically. So that's the recommendation even at this stage. We don't know the details of how this gateway test is going to work yet, but I'm not sure it's going to provide actually a lot more help than we currently have because of those reasons. So there's also discussion at policy level about removing remedies for employees who commit serious misconduct, including removing reinstatement. The bill for this, we're expecting that to come in at some stage this year. I mean, at the moment, the legislation provides that people's contribution to their personal grievance, so what their bad behaviour is that's led to them being dismissed, say, has to be taken into account and remedies reduced in light of that anyway. So how this will actually apply to limit the ability for people to get access to remedies is a little hard to read. There'll still need to be some checking of whether what happened was or wasn't serious misconduct, so still some checking around substantive justification for dismissal. And it'll be interesting to see how the legislation navigates carving that out from the Employment Relations Act protections at the moment. You could see that potentially employers, if this is passed, will try and demonstrate that behaviour is meeting that much higher standard more often to be able to exclude personal grievance claims. But we need to see what the bill looks like. So this particular promise change could be a really big deal, but we need to see what the detail is in terms of the actual draft legislation. There is also a bill working its way through which basically allows employers and employees to be able to agree that the employment relationship should end, to be able to talk without prejudice, which is currently, the ability to have off-the-record discussions or talk without prejudice. There are particular circumstances that can happen in the employment relationship at the moment. This would make this much easier to happen. And we expect that this is likely to be supported, and we're waiting for a first reading on it. Holidays Act reform. This is a big one. As an employment lawyer as employers who are dealing with the Holidays Act in practice all the time, don't we all just live in hope for a better piece of legislation around this? The government has promised us that. It has said we will pass a new Holidays Act before the end of our current term. I'm thinking, gosh, we've got a long time to run, really. So when is that going to be? We don't have any indication. There will be a lot to go through to try to make sure that it's a better law than we currently have, because there's a lot of detail in the Holidays Act. We don't know yet what it might look like. There's no draft bill. The recommendations from the Holidays Act working group around this have led to the minister saying, no, we need to start again. Let's go back to the drawing board. Some of the suggestions about what could be included could be hours-based accrual of holidays, which is how many employers are actually doing things in terms of their payroll at the moment, even though the legislation provides for weeks accrual rather than hours. So there's a lot of detail to come with this, and the government's given itself a pretty long runway in terms of just getting this done before its term ends. So I don't have a lot of information to give you about that. I'm an optimist. Let's hope that we end up with something better than we've got at the moment. But there's a lot to unwind around this before we actually have any better insight there. So those are the reforms we can expect in the employment law space. And now I'll just turn to some updates on cases, and I'll just talk to these fairly briefly and just give you the headlines, because there's a few to get through, and then we'll wrap up with the health and safety update. This particular case we're starting with is an Employment Relations Authority case. I wouldn't normally share with you things at the authority level because they don't have precedential value like things at the court level do. But I think it's important to highlight because it was a case where the authority, for the first time, has actually set compensation for an availability provision that it said should have been in the employment agreement and wasn't in there correctly. So the authority, there have been a number of other cases looking at whether compensation can be set if availability compensation isn't included in the employment agreement. And this is the first case where this has actually happened. And the authority did this by calculating what the people's gross wages were on a weekly basis, and then how long they were going to be available for, and then making a decision that they should be paid for time that they had to keep themselves available to work but weren't promised work at the normal hourly rate of pay. So again, at authority level, so it's a low level decision from a precedent perspective. The message for you as employers is if you've got anybody in your business who's having to work potentially outside just set hours and they're not already paid some compensation for that requirement to stay available to work when there's no promise that they will actually have work, then your employment agreement needs a look at to avoid possible claims for availability. And there are a number of cases around people saying, well, I'm on a salary, but my employment agreement says that I'm required to be available at any hour, whatever's needed to get the job done. I'm effectively having to be available to work 24 hours a day. Whether they actually are being required to work or not is a different question, but having to stay available to do that. You could potentially have arguments with each of those people about the fact they should be compensated for each and every hour that they're having to stay available. So hours of work provisions need some attention, would be my suggestion, to avoid this risk, which we're really seeing play out in litigation. The next case is about an employee who didn't give notice, and she had in her employment agreement a clause that said, if you don't give notice, you have to pay us the equivalent. This case was tested in the employment court. It's a fairly common clause in my experience. The court said that's not enforceable. That's actually an unreasonable penalty clause, that the person has to pay a penalty to the employer, when actually if you want to enforce a clause like that, it needs to be reasonable, as at the time the agreement was entered into. You have to demonstrate as the employer who's pursuing a claim, what were your actual costs, and then are they actually reasonable to recover from the person? So this person left in the middle of a holiday period. The employer said, what good extra costs in terms of having to get temporary cover for you. And it was difficult to do that at this time of year because it was the holiday period. Well, you actually weren't paying this person's salary, so you haven't actually lost any money. You've not had to incur additional costs to replace them, so you can't recover that from the employee. So the message is, if you want to be able to claim against an employee who doesn't give you the appropriate amount of notice, we should have a look at how your clause is drafted, because it's quite important to whether that would be enforceable. I promised you a little bit of case law on the contractor relationship status challenge, where a person can argue, I'm engaged as a contractor, that's what my agreement says, but I'm actually an employee. And there's a lot of litigation that's happened over this in a number of industries, the courier industry, for example, the building industry, which is based on contracting arrangements mostly. And this latest case, which went all the way to the Supreme Court, is a case involving Uber drivers. So I would have thought Uber drivers are the classic example of people in a gig economy, and how could they be anything other than contractors? The court says, no, they're actually employees. And I guess the indication around this is that the application of the law as it stands about whether someone's a contractor or an employee has really progressed. So if you are using contractors in your business, you should have a look at those arrangements and have a bit of a risk assessment about whether they could potentially challenge the status of their relationship, because if they did that successfully, they have access to all minimum employment rights, including holiday and leave entitlements, back pay for those for the duration of time they've been working for you, access to personal grievance claims as well. So pretty big risk profile probably for employers who use a lot of contractors, and it's worth a look, regardless of what's happening with the gateway test, because of where the case law's at with this at the moment. TVNZ had a big fight with one of its key unions, ETU, about redundancy consultation, and was actually stopped from progressing with its consultation around redundancy because ETU argued successfully that it hadn't met its obligations under the collective agreement, and there was a particular clause that TVNZ had to consult people before they got to the stage of putting out a restructuring proposal. So the high-level takeaway for this is make sure that you have a close look at what your employment agreement obligations are around restructuring consultation, and that those are followed. This is particularly important in the union landscape, who often have additional obligations tailored into the collective agreement. And if you don't, then you could be stopped from moving forward with your process by the union taking action. And then, so the last employment case is Stellar Elements and Amesbury. This case involved the restructuring of a New Zealand business of what was part of a global business, and the businesses globally were connected. In this case, this person who was in a senior role was made redundant. They argued, well, employer in New Zealand, what if I wanted to move and work for your group company in Australia? You should have considered that. And the court gave an initial comment on this saying, yes, employer in New Zealand, you might be the entity that employs this person, but you've got other group companies that you're connected with, and you should look more broadly at whether the person could be redeployed rather than just making them redundant based on what's available in the New Zealand business. This is a pretty big deal for employers because while it's not a definitive comment from the court, I am starting to see this play out in restructuring processes where people who are aware of this case are saying, well, I might not be able to continue working for this business, which is based in Wellington, but you've got other entities throughout the country, and I'd be happy to relocate. Can I look at moving to your business that's based in Christchurch? The general position has been, well, the employer is the particular entity that the person works for. It's not other entities, even within a group of companies. And so arguing that the employer should look more broadly at other possible entities really expands the scope of what the employer has to do, I think, beyond what the law had anticipated. And so if you're in the situation where you've got more than just one company within a group that you're working in, it's worth getting some advice about what that means for your restructuring processes. Okay, so swiftly moving topics to the health and safety field. There are a couple of highlights here. Very much high-level policy discussion going on in terms of whether HSWA, the Health and Safety at Work Act, is fit for purpose. Government, when consulted with the public widely around the country late last year, there were public submissions that were open and closed in October last year. This isn't an urgent matter, but the government has said, we're going to make it easier. We're going to make it simpler for employers to comply with legislation. It needs to be fit for purpose. Honestly, I've really heard mixed reviews. Actually, I was reading some of the comment sections, which is always enlightening, about in some of the articles that talk about this, and people are saying, do we really need to complicate things when we're just getting to grips with a piece of legislation that's been in for 10 years by giving us something new altogether? Is that really going to help practically, business in terms of compliance and in terms of the costs around that, and in terms of keeping people safe at work? So, it'll be interesting to see how a bill progresses with this. I think the bill would need to be very well considered. Like the Holidays Act, it would be significant change. and this isn't progressing with urgency. So the government's promised it, but we don't know much more about what it looks like at this stage. Psychosocial risk management is another piece that's progressing, and feedback closed late last year. We're awaiting an update on this. This is to do with WorkSafe planning to put out some guidance for employers on managing psychosocial risks at work, and a work in progress in terms of what that looks like. My takeaway point for you about psychosocial risk management is that we're seeing this every day in terms of it being an issue in employment processes where people are saying, I'm stressed, I'm fatigued, I can't come to work because of this, my mental health is suffering because of what's happening at work. And I think that businesses, if they don't already have something in place around psychosocial risk management, need that in place like immediately, because it's not just a health and safety work safe risk, it also is really important for your employment processes. And actually we have a mental health and wellbeing psychosocial risk management toolkit, which you can purchase for a fixed price to give you a head start in terms of rolling out something for your business if this isn't already covered in your health and safety management plan. You can have a look at that on our website, or feel free to get in touch if you're interested in knowing more about that. Very much a live area, so I'm not sure that WorkSafe's guidance about how to simplify it for employers will do a lot in terms of making it more straightforward for you to put things in practice. I think you'll probably still want to get some help with this area if you're not already covered with it. And then lastly, on the health and safety front, who hasn't heard about the Tony Gibson, ex-CEO of Ports of Auckland case, where he was prosecuted as an officer of that company for the death of an employee and his due diligence failures as an officer of that company in respect of this. It's been all over the news, and it's the first time this has happened in New Zealand. It's signalled a shift away from officers in larger companies being held accountable for health and safety in both Australia and New Zealand. In Australia, those cases have tended to move away from those prosecutions being successful for people in this size organisation who are at the senior level, and in New Zealand, prosecution of officers has generally been for smaller businesses where the officer really is very close to what's happening. It's just, maybe a couple of directors and then them working directly in the business. Why was Tony Gibson prosecuted? Well, health and safety was 30% of his performance metrics in terms of his job description. There was discussion about his awareness of specific health and safety issues at the port and the approach that was being taken to those. And so he did have a depth of personal knowledge around that. And the company had received a number of recommendations years earlier about changes that should be made that hadn't been actioned. So there's a lot in this case in terms of the detail, but those are probably three headlines that are important. And the message is that basically the approach to health and safety that even larger companies are taking needs closer attention in terms of what's happening with due diligence duties at the officer level. And that's something that people do have that personal responsibility for. And we now know the approach that the court will take to that. So those are the headlines on the employment and health and safety aspect. And I'll hand over to Shush, who's going to talk about immigration.
Cool, thanks for that, Kate. So just to go over what I'll be talking about today, I'll be covering what we're seeing at the moment in the immigration space. I'll be covering what's on the horizon in terms of changes that will be coming into effect in 2025. And then if we've got time, we'll go into sort of a few case studies. So just moving straight into it. So what are we seeing at the moment? So the first thing we're seeing at the moment is faster processing of job check and accrued employer work visas. So for background, these applications were taking a month or two to process previously last year. At the moment, what we're seeing in terms of processing times are probably closer to 1 week or 2 weeks. So it's a lot faster in terms of turnarounds when you're looking to support your migrant workers. The second thing we're seeing at the moment is stricter processing of job check applications and applications overall. But in relation to job check applications, what we're seeing now is previously immigration will provide some leniency while the accredited employer work visa category was sort of in its infancy. And they would, for example, allow employers to re-advertise job advertisements if job advertisements didn't have required information or if they weren't compliant. Now we're seeing more often than not, Immigration New Zealand is declining applications. Job check applications, and they are asking applicants who submit job check applications to re-advertise and then submit new job check applications with new job advertisements. The third thing that we're seeing at the moment is we're seeing stricter penalties for visa breaches with consequences including deportation. I'll talk more about this as part of a case study, but in essence, for simple breaches where, like for example, your migrant workers are working in a location where they're not supposed to, Immigration New Zealand are raising infringement offences and also raising deportation liability against those migrant workers who aren't working in the locations or roles that they're supposed to be working in. From a sort of recruitment perspective, what we're seeing is there's still a lot of interest from your skilled migrants who want to migrate to New Zealand. There are a lot of border movements throughout 2024. One of the things that the migrants are having a hard time with is being connected to roles that they're potentially skilled and able to work in. That seems to be the biggest roadblock in the sense that skilled migrants are having a difficult time obtaining the job offers needed to support them for work visas. Another thing that we're seeing at the moment is delayed processing of accreditation where there are allegations of migrant exploitation or prior breaches. Even when those allegations of migrant exploitation, when those allegations are not founded or not supported by evidence, or where there are breaches, like for example, simple breaches and little minor breaches in the sense that, let's say, you're supposed to pay your migrant worker $29.66 per hour, and then let's say for a few months you've paid them $29. Immigration New Zealand are taking a longer time to process renewal of accreditation applications for those employers there are breaches or there's a potential that the employer is a high-risk employer. The second to last thing that we're sort of seeing at the moment is incorrect application of immigration policy around maximum periods of stay, especially when there are migrant workers working in ANSCO skill level 4 and 5 roles. And I'll talk more about this later as part of a case study. The last thing that we're still seeing at the moment is lots of changes on the horizon for 2025, which I'll go into shortly. So moving on, in terms of the changes that we'll be seeing this year, I'll start with probably the biggest change, which is the transition from the median wage rate to market rates. So previously, Immigration New Zealand had used market rates, and then after the accredited employer work visa scheme was introduced, Immigration New Zealand introduced median wage rates. So the current median wage rate is $29.66, and there are a bunch of exemptions that can be sort of tacked on for specific roles. But in general, if you want to hire a migrant worker right now, you still need to pay your worker $29.66 per hour and guarantee them at least 30 hours a week. Now, from March this year, Immigration New Zealand will switch over to using a market rate, and that will provide a few benefits to your employers that operate in a space where they employ workers anywhere from above minimum wage rate to upwards of, let's say, $30 an hour. The biggest benefit there will be a reduction in the bottom cost for wage costs. So, for example, if you have a worker working in a role where, let's say, they're getting paid $29.66, their sort of 40-hour gross pay rate per annum is around $61,000. The change will allow, for example, a saving of upwards of $12,000 if a role is offered at the minimum wage rate, which is $23.50, and if it's let's say $25 per hour, there'll be a saving of $9,600 approximately per worker per year. And if it's the living wage of $27.80, there'll be a saving of around $3,800 per worker. So in essence, what we're seeing is this is a positive change, but it'll need to be navigated with care, especially where there are, let's say, workers already getting paid a higher rate. But that will probably be one of the bigger changes this year, that if you're looking to recruit for roles, and you're looking to put potentially migrants into those roles because you can't find Kiwis to work in those roles, there'll be the option to pay those migrant workers a bit less than what your company is required to pay them right now. Moving along, there'll be a removal of the requirement to complete Employment New Zealand modules for both HRT members employed by an employer who make employment decisions in regards to AWV workers, and also for workers who are signing up and joining a company on an AWV. There's no requirement for them to complete Employment New Zealand modules, which will be a nice thing to drop off in terms of compliance, one less thing to check off. A further change that'll be coming in this year will be the allowance of use of declarations for job check applications. And what this really means is, as part of job check applications, if an employer can tick that the labour market test has been satisfied, then that will allow the job check application to be approved without potentially further evidence. From a compliance point of view, this can be a bit tricky because what that means is employers will still need to advertise for the required periods and, for example, engage with work and income / MSD when necessary. However, it just means that less evidence needs to be submitted to the job check application. All the steps still need to be followed, but the employer will need to build in processes to make sure that these checks are being completed so that when they are audited by Immigration New Zealand, it's not the case that false and misleading information has been provided in terms of promising and in instance promising that requirements are met when they haven't been met. The next thing that we're going to see is immigration will start in essence, categorizing employers as high-risk employers and sort of your low-risk employers. Low-risk employers will have benefits in terms of faster processing of accreditation job checks and accredited employer work visas, where for your high-risk employers, there will be hurdles and delays with the processing of applications at every stage. So the takeaway there. It's important to make sure that you completed audits if you're employing migrant workers to make sure that you're not assessed as a high-risk employer. Another change that will be coming, is already in force, is the declining of incomplete applications. So, and also the grant of extensions. So, still a large amount of applications that are submitted, whether it's an accredited employer work visa or a job check application. These applications are still being submitted incomplete. Previously, immigration were quite lenient when it came to granting extensions for documents to be added in and so forth. What we'll probably be seeing more of now, if not already, is immigration will be declining applications where not all required documents have been submitted at the outset. And it's probably going to be less likely that extensions are granted for documents. A further change will be in regards to the maximum period of stay. This one is already in effect at the moment as well. But I think it's one of those changes that sort of has been in the background, and employers are sort of sometimes don't really understand what it means. But in essence, in your hospitality space, for example, at the moment, or your tourism space, you'll have workers who aren't paid the median wage rate, who will have maximum periods of stay of, let's say, between 2 to 3 years. It'll be this year that potentially they will need to either be promoted into a different role that's ANSCO skill level 1 to 3 from, let's say, a ANSCO skill level 4 to 5 role to be able to remain in New Zealand, or they'll need to start leaving New Zealand and staying offshore for at least 12 months to be eligible for a further work visa. So just a recommendation here to do an audit of your workforce to see what ANSCO or National Occupational List skill level the roles are, because for some of your workers, your migrant workers who have visas expiring this year, they might not actually be eligible for a further visa unless there's a change in regards to their role. There are some changes in the labour hire accreditation space as well, specifically in regards to, or in the space of the construction sort of companies that offer labour hire in the construction sector with reduced thresholds, which is fantastic. I won't talk too much about that. Another change will be in regards to the minimum skills threshold. So currently, for a worker to be supported for an accrued employer work visa, they need to have at least 3 years of relevant work experience, a bachelor's qualification, or a level 4 to 6 qualification that's comparable to a New Zealand qualification of between level 4 to 6 that's relevant. There will be a change coming into effect where for ANSCO skill level 4 to 5 roles, instead of having 3 years of relevant work experience, that will drop to 2 years, which will be fantastic. So I guess 2 points there. Just a reminder, there is a minimum skills threshold. If you're an employer and you, for example, send a job check token to a migrant worker that doesn't meet the minimum skills threshold, it is a breach of accreditation requirements, and it will need to be explained. So it's quite important to just keep on top of the minimum skills threshold when looking to recruit migrant workers into roles. The last change I've got on this sort of slide is in regards to interim visa changes. So previously, when you're hopping over from, let's say, a working holiday visa to an accrued employer work visa, there would be interim visas granted which would not have work rights. Now, from March this year, my understanding is the interim visa policy will be changed. So anyone submitting an accrued employer work visa, regardless of the visa they held previously, as long as it's not a limited visa or a visa with conditions not allowing the person to apply for another visa, if they apply for an accrued employer work visa, they'll be able to continue to work while the accrued employer work visa hasn't been processed. So that will be a positive change. With probably some details that might change that scenario. But for example, it's good news. For example, if you're in the space where you're employing working holiday visa holders already in one role, and then you're supporting them for an accrued employer work visa to work in the same role, it'll be a positive change in the sense that you won't have to put those workers on stand down if their accrued employer work visa isn't approved before the expiry of their working holiday visa. Moving along. The first change I've got on this slide is an increase in visa duration. So in essence, what immigration will be doing from March onwards, and to some degree already, is they'll be granting accrued employer work visas for 3 years for workers working in ANSCO skill level 4 to 5 roles. This is a change from only granting, for example, the visas for 2 years. So that will, in essence, mean that workers will have access to a 3-year accrued employer work visa if they're working in an ANSCO skill level 4 to 5 role, and they meet the medium wage rate currently or the market rate once the change comes in. So that's a positive change. The second change I've got on the slide is a recent change. It's something that's enforced now. So previously, immigration allowed for people traveling into New Zealand for the primary purposes of holidays to work remotely. There was a period during the Labour government where they changed the requirement. And in essence, what the government have done now is put into policy, in a sense, visitor visa instructions, which will expressly allow visitor visa holders who travel to New Zealand for the primary purpose of holidaying and sightseeing and so forth to be able to work remotely. So that's a positive change. I've got seasonal workers as a change or a space where there'll be change this year. And I think the biggest changes there are, firstly, in the specific purpose work visa space, there's a special category for seasonal workers. For example, those working let's say on ski fields and so forth. There's a specific purpose work visa category that can be used instead of the accrued employer work visa category for those workers without the need or a requirement for a job check application to be approved. So that's a fantastic change. Also, around November this year, I think the government will start to release information in regards to a new seasonal worker category, which will be fantastic. Moving along, there'll be greater work rights for those on interim visas. So I've already covered that. And the second to last change is a move from ANSCO to NOL. So the acronyms being Australia, New Zealand, Skilled Occupation List. So previous and also currently, Immigration New Zealand uses ANSCO to, in a sense, associate skill levels with different roles. Immigration New Zealand have announced that they will be moving to, in essence, a New Zealand national occupation list sometime in the future, and potentially that might be sometime this year. So what that means is for any of your roles that you've got migrant workers on, it would be positive to start looking into comparable roles on the national occupation list, because there might be changes in skill levels which might be favorable or not favorable, and which may or may not, for example, one, allow your migrant workers to remain in their roles to work longer, or to change could mean that they might be able to, but they won't be able to apply for a further work visa in New Zealand unless there's a role change. The last sort of change on this slide I've got is in regards to the active investor plus category. To drive, I guess, economic growth, the government have introduced a new active investor policy. I won't go over the details of the policy too much, but just putting it in there. Moving along, and I will just move into some case studies of areas where we're seeing employers have difficulty. So the first one is job check applications. Now, and also the stricter processing of those job check applications. So one of the things that we're seeing is sort of incorrect understanding of policy. So, for example, at the moment, there are, as an employer, you'll fit into two spaces. One, you'll have already approved job check applications for migrants that you've employed initially, let's say throughout 2022 to 2024. Now, those job check applications can technically be reused if a worker is working in an ANSCO skill level 1 to 3 role. Now, they can't be reused if the role is ANSCO skill level 4 to 5, and the workers aren't, for example, care workforce or work to residence category. So I guess just in terms of a case study reminder here and a takeaway, just be real careful around reusing already approved job check applications, because you can't reuse those applications to support workers for a balanced accredited employer work visa application in certain scenarios. And it might be better for certain roles, like for your ANSCO skill level 4 to 5 roles, which is the second scenario, potentially to submit a new job check application. Because let's say you've got workers still that you want to support for an ANSCO skill level 4 to 5 role, and you can't find Kiwis to work in that role. Potentially, if they're still paid the median wage rate at the moment, they can be supported for a further year to be able to work on an accredited employer work visa while still working in the same ANSCO skill level 4 to 5 role. So we're just seeing a bit of sort of incorrect understanding around this policy in particular, and wanted to sort of highlight that as a case study. The second sort of case study that we'll go over at the moment is, actually, it's sort of what I've just covered, so we'll just move along. It's in regards to your high and low risk employers. So what we're seeing at the moment is, so even for your larger employers, if there have been, let's say, breaches in accreditation, sort of compliance. So let's say a worker is not being paid the correct rate, or if there have been any allegations of migrant exploitation, especially those that have reached the media level, just to potentially expect delayed processing times. So we've seen on more than one occasion now where renewal of accreditation applications have taken 6 to 9 months to process, instead of, let's say, your normal sort of potentially processing time of within 1 month, just because when an employer is sort of classified as a high-risk employer, there are additional checks, internal checks that immigration needs to complete, and when completing those checks can take a long time to process, spanning sort of your 1 to sort of 6 months to process, which will add processing delays to the to renewal of accreditation applications. So I guess the takeaway here is just, if you've had some issues with, let's say, accreditation breaches, or issues where prior employees have complained about migrant exploitation, just to factor in a longer processing time, because potentially that may be required. Okay, cool. And then the last case study I've got here is in relation to breaches, infringement offences and deportation. So in essence, what we're seeing here is for simple breaches, like let's say on where you've got, let's say, accredited employer work visa holders and they're supposed to work in a specific role, the role is set out on the accredited employer work visa. They're supposed to be paid a specific rate. They're supposed to be working in a specific location. If these conditions are being breached, immigration is taking quite a hard line to the breaches and raising infringement offences. We're aware of at least one employer where it was a simple matter of the worker working in Queenstown instead of Gisborne. So their work visa only allowed them to work in Gisborne. And unfortunately, they were working in Queenstown for a prolonged period of time. And the compliance team identified that breach. Now, for the employer, what that has meant is that their accreditation has been revoked because an infringement offence was raised. They had to pay around and upwards of $6,000 for the infringement offending because there were two workers, and they've been barred from migrant workers on accredited employer work visas for 12 months because they've had that infringement offence raised against them. Now, at a worker level, just for that simple breach, what that has meant is that the worker has actually been deported, unfortunately, and they are now subject to because the matter, when they were handling it, they weren't getting correct advice. Because they hadn't taken appropriate steps, the workers are actually barred from travelling to New Zealand for at least 5 years, unless there's some intervention or work there that's completed to remove that bar. So it's, I guess the takeaway here is even for your very simple and minor breaches, immigration is taking a very hard line that will have significant consequences for employers and the migrants that employ migrant workers, and also have significant sort of negative consequences for your workers as they might be deported and barred from life visas to travel to New Zealand. The sort of last case study that I'll go over is, so what we're seeing at the moment is with the transition from the medium wage rate to the market rate, we're starting to see employers advertise now with sort of your job advertisements ranging from $25 an hour upwards to $30 an hour, just to replenish their workforce, because they're identifying that, for a cohort of their workers, that cohort might not be able to remain in New Zealand past this year, especially if they're working in skill level and skill level 4 to 5 roles. So I guess just the takeaway here is to do an audit of your workforce just to see who can apply for a further work visa and stay in New Zealand and who can't, because it could be the case that you might need to start looking now to replenish your migrant workforce. I guess as a call to action, with all the changes that are sort of happening this year and all the changes that you already keep in track of, if you and your business don't want to be caught out, we strongly recommend getting in touch just to get an audit or some training done. In terms of what we're offering, we're happy to offer training in regards to immigration changes and also audits in regards to compliance. So we've got a get up there to help with detailed cheat sheets, in-person training, and so forth. That's all from me.
Awesome, thank you, Shosh. Alice, we'll open the floor to some questions now. Have we got any questions in the chat?
We've got one from Liana. She missed a description of the 2 locations where the employer thought they could work their worker over 2 locations. Was it 2 different towns, countries, or branches of the business?
For that case study, it was the locations were Gisborne and Queenstown. So there were 2 different locations. So Gisborne is outside of Queenstown. And because the workers had accredited employer work visas that only allowed them to work in Gisborne, but they were working in Queenstown for the same employer, that's considered a breach of an accredited employer work visa condition. And immigration unfortunately took a very hard line to prosecuting them.
Thanks, Shosh. We got anything else here on the chat, Alice? Or feel free, anybody can unmute themselves and ask questions if they have any at this stage as well.
Nothing further on the chat. at this stage.
Okay. In terms of the how we can help or the employer to-do list, I suppose, out of this, one thing I would suggest is, in terms of keeping up with the changes, we'll be running some more training as the bills are actually progressing about what that specifically means for employers. And you're welcome to subscribe to our In Touch publication as well on our website with this. There are a number of other things that we can assist with, including workforce planning and immigration support, and Shusha's advised you have an offer there, closely reviewing your contractor arrangements, making sure your policies and agreements are up to date, including as they need to be changed to comply with the new law or to make the most of the opportunities that the new laws present. We have the mental health and wellbeing toolkit, which is a fixed price offer, which is available on our website to look at, and feel free to get in touch about any of this if you'd like to. If you think in your organisation that people needed more of an update about what's coming or some of these key issues, feel free to get in touch. We can also do bespoke training for people, either virtually at our offices or at your offices, as suits best.
Cool,
and Alice, I
was going to say we've got some more questions come through. So I've got one from Mike, and he's asked whether can these workers then travel overseas for work?
So if you've got a migrant worker on a career employer work visa and as part of their role, they need to travel overseas for work. I don't really see any issues there. They should be able to, as long as the country that or the area that they're traveling to, they hold an appropriate visa to travel to, and they're coming back to work in the same role. I don't really see any issues with career employer work visa holders traveling offshore for work-related conferences. There's another question there in regards to changes for ANSCO School 4 to 5 visas. In essence, the current position is if you've already got a job check application that was approved, let's say some time ago for the initial career employer work visa, that can't be used. A new job check application will need to be approved to allow the worker to work in an ANSCO Skill Level 5 role, especially if they're a new worker to the business. And to answer that question, a new token will generally be required for a worker working in an ANSCO Skill Level 4 to 5 role to be supported for a 3-year visa. Just to take care around the maximum period of stay. So, for example, let's say the worker had already held a career employer work visa for, let's say, a year or even 3 years. In a scenario of a year, they'll be approved for the balance of that 3 years, because workers can still only be only work in New Zealand for 3 years on a career employer work visa, that's skill level 4 and 5, unless they work in a, let's say, sort of work to residence role, like let's say your aged care workforce sort of roles. So I guess to just look back and answer that question, yes, the new token will be required. I've got another question in regards to the change for AWV employees that continue to work whilst their applications are in. There isn't a specific date, I think, in regards to that change, in regards to interim visas. There'll be some time in March that the interim visa policy will change, so that anyone who submits a career employer work visa who's already working in a role, let's say on a working holiday visa or something like that, can continue to work as long as you've got a career employer work visa that's submitted. And then another question in regards to remote workers coming to New Zealand for meetings. I think I might need some more specific information around that, but the new remote work policies are quite specific in the sense that in essence, the remote work has to be for an offshore employer, and it shouldn't be something where, for example, let's say you've got a or like a global organization, and the person is coming in to work for, let's say, the New Zealand arm of that global operation. Hope that answers the question there.
Could reach out directly. Okay.
Kate, I've got one for you from Jess, and she's asked, how likely is it that employment agreements will successfully include a provision for higher paid workers to still be able to lodge a PG, essentially overriding the proposed law?
Yeah, I think what we'll see is people who are on those higher salary brackets, they'll be looking to negotiate in things like this to their employment agreements. So you can, because the law will be contracting out of minimum employment rights, I expect you'll be able to negotiate to put things back in, but we need to see the draft legislation to be able to say. So yeah, and I think the thing is, if you're the employer, and you want to secure that talent. It's like with trial periods. Like technically you can use a trial period for a senior employee. How many of you do? How many senior employees are willing to give up stable employment or to come and join your team if they think that they're at risk of their employment being ended with no right to recourse within the first 3 months? I think it'll be possibly a similar thing. Yeah.
Thank you. And then another one from Lauren. This is for you, Shosh. Sorry, she said, apologies if this has already been asked, but regarding AEWVs, has the market rate list been released ahead of the March change from 29 to 66? Will there be a list?
So based on our understanding of what the change will be is Immigration New Zealand will sort of resort to your sort of seek.co.nz market rates, your pay scale market rates, your careers.govt.nz market rates, and so forth. So instead of Immigration New Zealand having market rates, they'll just say market rates in the policy. And when processing job check applications, they'll refer and compare job advertisements to sort of your market rates on those websites.
Oh, thank you. And then Mike's just clarified that remote IT question. He's asked about IT workers that are employed by an NZ entity needing to come to New Zealand for a week for meetings, then returning home.
Yeah, that one's, I guess, just generally speaking to that, that will most likely not fit the new work. So remote work sort of changes, but there is, it really depends on what the workers are coming in to do. If they're coming to do, let's say, IT work, like specialist IT work, then I think a specific purpose work visa will be required if that work is for an NZ entity. But if it's something more, I guess, for, let's say, growing a business and it's all sort of more high level, sort of your senior managers, then potentially a business visitor visa might meet the requirements. But happy to take that offline and provide some more detailed guidance.
Wonderful. And then one more, Kate, just for you from Rob, saying, would an employee experiencing stress due to reduced hours come under psychosocial?
Yes, possibly. Yeah, that's the thing. This issue of I'm stressed, whether it's because of a change that the employer's making, whether it's because of personal things that are going on for the employee and remembering they bring their whole selves to work. So you're seeing that show up in what's happening at work. All of that is relevant to you needing to have a framework in place to turn to about how to manage those risks that arise. So yes, potentially. It's not so much whose fault is the psychosocial risk, it's what is your framework to manage it, and to be able to point to that is very useful in terms of managing claim risk as much as meeting work-safe obligations. So there's 2 pieces there. Yeah, thank you so much for your participation, everybody. Thank you so much for your questions. I'm always keen to make sure we can get people on with their days on time and get wrapped up with the time frame we've given you. So we'll wrap up there. And Shosh and I are both, I'll speak for myself, total geeks about this area. I love this, the area that we work in. We find this stuff fascinating and the changes fascinating. Always welcome an approach to discuss anything and what it might mean for you. We love talking about this stuff, so feel free to get in touch. And thanks for joining us.
Oh, thanks.